Okay, so I think we're going to start. Welcome, everybody, and thank you for joining us for this virtual side event on human rights in the United States. It is one of a series of side events that the Advocates for Human Rights are hosting this fall in the lead up to the 36th session of the Universal Periodic Review Working Group in November 2020. The Advocates for Human Rights is a non-governmental organization based in the United States which works to implement international human rights standards in order to promote civil society and reinforce the rule of law. One of the ways we do so is by collaborating with partners to build their capacity to engage in advocacy at the United Nations. The purpose of this side event is to provide delegates to the Human Rights Council with information they can use to prepare their interventions for the UPR Interactive Dialogues in November. My name is Lindsay Greising, and I'll be the moderator for this panel today. I'm a staff attorney with the Advocates, where I work on our research, education, and advocacy, focusing on immigration, human trafficking, and other special projects. Before we begin, I'll go over some logistical information. The panelists will each present their topic for about 15 minutes and leave 5 minutes thereafter for questions before moving on to the next topic. Please ask your questions via the Q&A box found at the bottom of your screen. We will try to get to all of your questions, but any follow-up can be directed to Elizabeth Lacy by email at elacy, L-A-C-Y, at advrights.org, and we'll put her email in the chat. I think it's also on the main screen. For all of the topics we will cover, we've prepared one-pagers with top-level summaries for our priority recommendations for the United States. If you have not received the one-pagers, please email Elizabeth and she'll send them to you. This is a public event. We are recording this event and we will publish the video on YouTube in the next few days. If you would like a link to the YouTube recording, again, please contact Elizabeth Lacy. Today's event will cover asylum in the United States, human trafficking and labor rights, and police accountability. I'm grateful to be joined by our 4 panelists who will offer specific recommendations they would like you to make to the United States and to explain why those recommendations are important. Lan Nguyen will speak about asylum in the United States. She is a shareholder at Frederickson and Byron and has practiced immigration law for over 20 years. She is co-chair of the Immigration Department and also leads the firm's Diversity and Inclusion Committee. She focuses on employment-based immigration, corporate immigration compliance, and global mobility solutions for employers, ranging from Fortune 500 companies to mid-sized companies, entrepreneurs, investors, and family-owned farms by developing practical immigration policy and strategies to meet their global mobility and immigration goals. Lan also leads Frederickson and Byron's immigration team's I-9 audit and corporate immigration compliance practice and H-2 practice. She is on the board of the Advocates for Human Rights and YWCA Twin Cities. She was a member of the Board of Trustees for the American Immigration Council. She has served on AILA's DOL Liaison Committee since 2015 and is the current H2 Vice Chair. She is also a frequent speaker at national conferences, served as an expert witness on H2 matters, and has written extensively on immigration issues. She is a girl refugee who fled from Vietnam in 1975 with her 4 siblings and parents. Veronica Mendez will cover labor rights and human trafficking. She serves as the co-director for Statutes, or Centro de Trabajadores Unidos en la Lucha, Center for the Workers United in the Fight. Statutes' mission is as follows. Statutes organizes low-wage workers from across the Twin Cities to develop leadership and educate one another to build power and lead the struggle for fair wages, better working conditions, basic respect, and a voice in our workplaces. Statutes is an organization of workers and for workers committed to securing fair working conditions for present and future generations. Veronica is joined by Martha Malcolm, who is an advocate for fair employment practices, is a longtime Statutes member, and presently serves as a board member. Finally, Carrie Brasser will cover police brutality. Carrie is a former litigation attorney with Jones Day in Chicago. While at Jones Day, Carrie handled numerous pro bono asylum cases with the National Immigrant Justice Center and continued to do so after leaving Jones Day. Since moving to Minneapolis from Chicago in 2018, Carrie has been working on a pro bono asylum case with the Advocates for Human Rights. Carrie was a French major and Government International Relations major in Georgetown University in Washington, D.C., and before law school at the University of Virginia, worked for the Office of International Affairs Criminal Division at the Department of Justice. While there, Carrie handled extradition and mutual legal assistance matters with French-speaking European countries. Lon, let's turn it over to you to start talking about current issues in asylum.
Thank you so much, Lindsay. Thank you for joining us to discuss the current state of immigration and asylum in the U.S. Since 2017, the U.S. has implemented policy changes which have resulted in systematic failures by the U.S. to protect human rights and meet its international obligations. I will discuss today 3 specific areas in which its failure have resulted in the death, inhumane detention, and or acts or violence against asylum seekers and immigrants in the U.S. First, its draconian policies and procedures to make it as difficult as possible to apply for asylum and protection under the Convention Against Torture. Its abrogation of due process and legal representation for immigrants in detention awaiting their asylum or removal proceedings, and the cruel, inhumane or degrading conditions in its detention centers, prisons for immigrants who are waiting for their asylum hearings and immigration proceedings. In 2017, the U.S. made it very clear that its immigration goal is to decrease the number of immigrants entering the U.S. on any grounds. This goal to make immigration as narrow as possible has resulted in extremely difficult conditions for vulnerable populations seeking asylum or protection under the Convention Against Torture in the U.S. For example, the U.S. implementation of the Immigrant Protection Protocols, also known as Remain in Mexico, requires individuals who arrive in the U.S.-Mexican border seeking asylum to wait outside its border in Mexico, where they have no legal status, to wait for their ability to apply for asylum and await for their asylum hearings. It has left over 55,000 asylum seekers in Mexico without little or no resources. In a recent study of 47,000 immigrants in the Migrant Protection Protocol process, only 11 were granted asylum, a rate of 0.1%. The conditions that the asylum applicants must live under while they await outside of the U.S. for their asylum hearings are appalling and dangerous. 1 out of every 4 asylum applicants have faced some act of violence against them. The lack of shelter and services is putting already vulnerable women and children at particular risk. Children are reported to be at risk of sexual abuse, gang recruitment, and violence, and women are vulnerable targets of criminal gangs engaging in human trafficking. We have learned that shelter capacity is very limited, so other people are living in makeshift camps, rented rooms, and hotels. The wait is also extremely long while they wait for their asylum proceedings due to the practice of metering by the U.S. Through metering, the U.S. places an arbitrary daily limit on the number of asylum seekers allowed to present themselves to U.S. authorities. Once they present themselves, then they must remain outside to await their asylum hearing. This current policy of Remain in Mexico makes it very difficult for legal counsel to have access to individuals to assist them with their asylum hearings. Through policy making and proposed rules, the U.S. has focused on narrowing also the grounds under which individuals can apply for asylum. For example, it has sought to expand the prosecutor bar beyond that is accepted by international law standards. In addition, it has implemented policies to narrow the definition of political opinion, membership in a particular social group, and torture. To further narrow the ability of vulnerable populations to apply for asylum in the U.S. has entered into safe third country agreements with countries such as Honduras, El Salvador, and Guatemala. These agreements allow the U.S. to require asylum seekers to seek and be denied asylum in transit countries first before they can apply for asylum in the U.S. The COVID-19 pandemic has also resulted in narrower policies by the U.S. to restrict the application of asylum. Last month, a recent report by the Customs Border and Protection revealed the U.S. extended a coronavirus border rule that has blocked nearly 43,000 migrants from seeking asylum at the southwest border. The improper use of national security grounds to bar asylum and entry based on COVID-19 and an expansive list of other health concerns is contrary to UN guidance. It's important to note that the restrictions to deter asylum seekers have not been due to a change in laws in the US by Congress or any legislative body, but the implementation of policies under this current administration since 2017. The second main area of concern is the detention and deportation of immigrants and asylum seekers without due process or representation. Under the US zero tolerance prosecution policy, adults face criminal prosecution for entering without proper documentation. This has resulted in the separation of more than 5,000 minors from their adult guardians or parents. Under this policy of mandatory detention, individuals who are seeking asylum are moved quickly without notice. Volunteer attorneys cannot provide adequate representation because in many cases, their clients have been moved without any notice within a day or two of entering the representation. There is a total lack of due process in current policies, in addition to the conditions that they are facing. For example, immigrants face mass criminal prosecutions for illegal entry. Detention, as I mentioned, is mandatory and with excessive bond requirements and lack of uniformity in bond determinations. Immigration judges have also been stripped of discretion to consider family ties or length of US residence or any other factors that may assist these individuals to obtain entry into the US due to the mandatory detention laws. Regulatory and policy changes have restricted judges' ability to close or continue cases and has sought to narrow grounds for asylum, leading to removal of migrants with bona fide basis for relief. We are also witnessing cruel, inhumane, degrading conditions for asylum seekers and immigrants in US immigration detention centers, which are often operated by private contractors. 2020 has seen the highest number of deaths among ICE detainees since 2006. The causes are mainly due to inadequate medical care or complications from COVID-19. There are reports month by month of individuals who have died in detention centers, immigrants who have died in immigration detention centers because of the lack of medical care or inadequate medical care. There has been overcrowding and unsanitary detention conditions along the US border, US-Mexico border, which has also resulted in the deaths of detained children. The current situation with COVID-19 has made it even worse. More than 5,000 people in recent months in ICE custody have tested positive for COVID-19, and there have been reports of death as a result of inadequate medical care because of COVID-19. ICE, Immigration and Custom Enforcement, also engages in a policy of detaining individuals and placing them in ICE box, which they place individuals in difficult conditions to break down and deter the asylum seekers they are detaining, with the goal of coercing them to agree to be removed or deported. The detention centers are a hotbed of deadly infections and medical issues that are just completely ignored or not provided with adequate care. The detentions of individuals at ICE detention centers have also resulted in abuse of workers through the voluntary work program at the Immigration and Customs Enforcement and private detention centers. A voluntary work program has been established which forces labor for thousands of detained migrants who earn about $1 a day by working in these work programs at ICE detention centers. These examples are some of the conditions that detainees and asylum seekers are facing at US detention centers, which, as I've noted previously, are mainly run by private contractors. To reverse the ongoing efforts by this administration to restrict the efforts of asylum seekers from seeking protection in the US and to protect those who are being detained in the US, we have the following recommendations. As Lindsay mentioned to you, we have a one-pager which lists out several recommendations, but I will focus on the main recommendations that we think are very important and necessary in order to reverse the ongoing abuses that we are seeing. We recommend the US take measures to ensure that detained asylum seekers have access to legal counsel and the opportunity to pursue their claims for asylum. We recommend the end of the MPP program, or the Remain in Mexico program, and metering. Individuals who enter the US to seek asylum should be provided the protection as required under international laws. We recommend that proposed regulations and policies that contravene non-refoulement obligations and provide inappropriate training and provide appropriate training to all Border Patrol, CBP, and ICE officers. It is important also for the US to take measures to ensure that detained asylum seekers have access to legal counsel. As such, we recommend that legal counsel be informed of where their clients are moved to while they're being detained. We also recommend that the US take precautions and implement safeguards and revise policies to prevent the deportation of individuals with pending legal claims or potential refugee or other protection claims in the US. And lastly, but not most importantly, we recommend that the US provide proper medical care to individuals under its custody. Lindsay, I will return it back to you for any questions that we may have regarding our presentation.
Thank you, Lon. There has been a lot going on in immigration and asylum policy in the US, and you did a great job covering it quickly. Please do look at our one-pager to get a bit more information, and feel free to reach out if you feel like you need more resources. Lon, we had a question from the audience, which is it easy for asylum seekers to access lawyers? Who pays the fees, as migrants have no money and usually are in a very difficult situation?
Unfortunately, the U.S. does not have a program which allows asylum seekers to have free access to legal representation. As such, they have to rely on organizations such as the Advocates for Human Rights to provide pro bono legal services. The difficulties here is that many of these individuals are detained in detention centers that are far from cities or areas that are very remote and make it difficult for pro bono representation or their representatives to meet with them and also to work with them. So a lot of the work is done remotely. So we in the US have to rely on pro bono free services from volunteer attorneys. It is not provided by the government.
Thank you. And one last question is whether if you could briefly explain the credible fear process and why representation is so important there.
Sure. So the credible fear process started in 1997 in the US. The law was passed in 1996. And the credible fear process requires that an individual who is coming into the US to seek asylum, if they are at a port of entry or at the airport and they have been determined to be in the US to seek protection, to seek asylum in the US, they are detained and until they await for a credible fear interview with the US Asylum Office. Throughout the years, the procedures have changed. Currently, individuals are detained until they have the credible fear interview with the Asylum Office to establish whether they have met the credible fear standards. It is not the same standards as asylum. It is not as high, but they have to show that they possess credible fear and the grounds in which they are seeking protection in the US. They are not automatically allowed counsel. They will need to seek counsel on their own, whether it's through a pro bono panel or service. And as they await for the decision, they must be detained. That is the process that they have to undergo. So for example, in the Remain in Mexico program, the individuals will come to a established place to basically present their credible fear claim. If it is accepted, then they can wait. Then they can apply for asylum, but they have to wait for the asylum hearing. And that is the concern due to the long backlogs and of course the current situation with COVID-19 too, with the border policies that the US has implemented. There will be a even more increase in the wait period for asylum seekers to apply for asylum once they've met the credible fear determination requirement.
Thank you. Again, feel free to ask questions using the Q&A function. And if there are no further questions, I will turn it over to Veronica and Marfa.
Marfa, would you like to start?
Yes, I'll start. Good. Okay, good morning again. I'm Marfa. I'm Marfa Malcolm. I'm a member of Statutes. Statutes is a nonprofit organization that organizes and trains people so that we can organize people into groups to learn more about our rights. I want to tell you about my experience with wage theft because it shows how real the problem is and how important the lessons on how to fix the problem. When I first came to Minnesota, I met a lady that do have a cleaning company, and she subtract she subtract 3 different buildings. She hired me and another woman, telling us that she would pay us $70 per night to clean 3 buildings. To begin with, I was excited. I thought I would help her grow her business, but after 2 weeks working, she did not pay us. So when I approached her and asked her for my salary, she threatened me that she would get me deported. Then, by the time, no, when I asked her about my pay, she began to threaten me, saying that she would mess up my immigration process, which I have going at that time. By then, she owed me $2,000. At that time, I didn't have any immigration status. I was also going through domestic violence. So I confided in her. And give her my passport and other documents to keep for me. She took advantage of the fact that I confided in her about it and said that she would hold my passport for me so that I could take. She took advantage of the situation. So, no, sorry. I'm so nervous about it because even now talking about it, it kind of like bring back the memories to me because it was a rough time. So she took my passport from me and said that she would hold it for me. Then when she took my passport now, she used that as a weapon against me. Not to pay me my wages. That was a strong thing for her to do. Then she retaliated against me and forced my signature on a piece of paper saying that she had paid me my wages, where she did not pay me my wages. If I knew what I knew now, then I wouldn't find myself in that situation. We tried to. If I knew what I knew now, sorry, very nervous. If I knew what I knew now, I wouldn't find myself in that situation. But then Statutes step up and help me to try to retain my money. We also tried to go to court. With her, but then I didn't have any proof to show that I was working in the building. Even though I have access to key entering the building, that wasn't enough proof for me, showing that I have proof to go there. Here are the lessons from this story. Workers' right is very important. Very, very important. I could avoid all this mess. Also, the building themselves need more legal responsibility. They couldn't produce record of me being in the building, even though I have the key code to show that I was there. This is a problem for their safety and we as workers. We also benefit from, the problem is this, they also benefit from my unpaid labor. I think they should be responsible for knowing who all the workers are in the building and making sure that the workers are being paid. I know that I am not alone. I have seen at Statutes where in the construction industrials, they target people who are undocumented. They use them for cheap labor and exploit them and trafficking them and steal their wages. We immigrants are like a bait to them. Once they found out that we are not from here, they use us as a bait. They know we are afraid of deportation so they don't pay us. And once they know that we are not from here, they don't pay us because they know that once we talk about it, they'll threaten us for deportation. I have seen many people at Setul become homeless, including myself. And we can't provide for our family because of the wage theft. Because of Setul, people have been more educated about their wages and their right. We have a lot of people who because of language barrier, become target. Setul help us to break through that so that we can stand up for our right. They know that they have support and help. Setul also help with interpretation because most of people that are at Setul, they talk Spanish. So because of the language barrier, they use people, they don't understand it, they just see and they just use you as a target for them. I think the US government should create a proper penalty for the exploitation bosses. Take away their license and create real penalty and fines when they're found guilty. They could help lessen how much they do to us, immigrants. Thank you.
Thank you, Marfa. My name is Veronica Mendez-Moore. I'm a co-director at Setul, and I'm one of the founders 13 years ago. So the issues that Marfa is raising from her situation and other folks at Setul are far from isolated. Since the day that our doors opened 13 years ago, we've been rushed with workers that are experiencing wage theft. And as we've seen the economy shift more and more to subcontracted workers, to temporary work, misclassified independent contractors, we've seen wage theft and other violations of workers' rights grow exponentially. In a seminal study that was conducted by the National Employment Law Project in 2013, they interviewed low-wage workers in 4 major cities in the US, and they found that of the workers that they interviewed, 2/3 of them reported that they had experienced some form of wage theft in the previous week. So that's a huge amount of workers, and that's a huge amount of wage theft. And frankly, it's an embarrassment to our country. In another 2012 study by the Economic Policy Institute, they found that the amount of money in stolen wages that year was $933 million stolen in wage theft, while property theft was only $341 million. Now, of course, that's still a lot, but wage theft is 3 times more money being stolen than through property theft. Yet proper attention isn't being paid to it. And we actually see in Minneapolis, we have 1 investigator for wage theft to every 350 police officers who investigate and deal with property crime. This is similar across the country. And since that time, the numbers of wage theft have increased, but the number of investigators and dollars put towards stopping wage theft have barely grown at all. At Setul, we've been organizing for the last 13 years to bring together workers who don't have a voice on the job. Unions have been under tremendous attack by our federal government for decades. And now that so much of that union infrastructure is decimated, workers have little ability to organize. They have little ability to organize into unions, particularly because work is subcontracted and independent contractors. So Setul is a nonprofit organization that looks for creative solutions, creative models of organizing, especially with Black and Brown low-wage workers, so that they actually have a vehicle to use their power to produce improved standards and working conditions. The right wing of our government, and particularly this administration, have done everything possible to strip unions of their power, leaving the barest skeletons, and then they've begun to go after nonprofit organizations and worker centers like us to destroy any ability that Black and Brown workers and working class people have to build power. Over the last 13 years, we've at Setul have won back over $2.3 million in stolen wages. and secured raises for workers that result in over $5.5 million a year back into the pockets of the most vulnerable workers in our city. We have trained and organized tens of thousands of workers to stand up for their rights and to secure new rights. Organizations like ours are critical and they need to be treated as such. And part of that is that at the city and the state level labor agencies, we need partnerships. Organizations like us are able to reach constituencies that would never approach the government out of fear because of immigration status, out of fear because of other reasons that they're vulnerable. And so it is critical to have partnerships, and particularly that there's funding coming from the government to ensure that organizations like ours can continue to do that critical work in partnership with them. So I want to add a little bit of information of what's changed since our submission to this committee, which is that across the globe, obviously COVID-19 pandemic has caused a tragic loss of lives, productivity, and has destroyed economies and social networks. The United States, as you all know, has one of the worst records in its willingness at the federal level to deal with the pandemic effectively. So as a result, we see frontline essential workers really bearing the brunt of the pain and the loss of life, particularly workers of color. So many essential workers are now going to work every day without sufficient personal protective equipment, without an employer's plan to have people social distance, without time to wash their hands and sanitize the necessary equipment. And these same workers are the ones that are retaliated against when they stand up to seek those basic protections. In fact, workers are often being forced to choose between working in unsafe conditions, unable to speak up just in order to bring money home to their families, or speak up and risk being sent home for quarantine without pay, or getting fired because their employer wants them to be more productive and doesn't want them to speak up. So it's a significant problem, and the crisis has really laid bare just the essential nature of frontline workers and the lack of respect and protection that they generally receive, and the chronic marginalization of all workers of color. So it's clear now more than ever that the importance of these workers are critically important to our economy and our society. Yet our federal government still fails to protect them. We know that when frontline workers are denied protection and safety, it impacts our entire society. It puts all of us more at risk for further increase in people contracting COVID-19. So now more than ever, worker safety is public health. If workers are safe, it improves public health. It's critical. It continues to be ignored by our federal government. And this is why we're here before you today, urging you to make our proposed recommendations to the United States to assure that workers are protected from COVID, but also are protected from all of the other egregious violations of their rights across the country. We want to make sure that workers have effective avenues to build power, that their voices can be heard, to ensure that they can live and work with respect and dignity that all people deserve. Thank you.
Thank you, Veronica and Martha. We have a couple of questions. The first one is for Martha. The situation that you described happened when you first came to the US. How is your situation now? Has there been any improvements? If you feel comfortable answering that question, great. Maybe you're frozen.
Yeah, it's a great improvement because out of bad becomes good. Because then when that lady stole my wages and I was directed to settle, and they helped me to get a lawyer. So the lawyer worked on my case, and then I was successful with my green card, and today I'm a US citizen. Yeah, so out of bad becomes good.
It's a happy ending story. The second question we have is regarding wage theft. Is the main issue the lack of personnel and other resources for investigation and enforcement? Is the law sufficient with sufficient penalties? And if not, what are the recommendations you would suggest to encourage the federal government to support workers?
Right. So fully funding federal and state labor enforcement agencies is key. It's wildly insufficient. I think that's a piece of it. And another part of our recommendation is to improve the law. So providing more protection against retaliation. Right now, protection against retaliation is very slim. The bar for what's considered retaliation is very high. And so it's difficult to actually use that clause in the law, and it needs to be stronger. And it needs to put the burden of proof on the employer, not on the worker. So the law is insufficient. The law also essentially, if you know, we've begun to change things a bit on a state level, but on a federal level, if workers complain that their rights are being stolen, often the worst thing or the biggest thing that they can get is just getting their money back. So the worst thing for the employer is just that they have to pay the wages back. And so it gives them an incentive. If they steal from 10 people and only one person complains, then it incentivizes wage theft by the employer. So we need laws that place bigger penalties on employers. And we also need laws that allow for more worker voice. We need laws that allow workers to be at the table. And again, this connects to retaliation, workers being able to speak up without being retaliated against. And another piece of that is providing more funding from labor enforcement agencies to the federal government, putting more into the enforcement agencies, and then those enforcement agencies partnering with organizations like ours who have access to workers that they don't, and who are the most vulnerable workers, and funding that partnership so that organizations like ours can do education and empowerment, so that we can end up with a lot of, you know, happy endings like Martha's, where people can actually ultimately have victory. Because right now that's not the case for a lot of people.
Great, thank you. And we have one question, if you have time, is how organized are the victims to face these challenges in a united way?
Generally not at all, because of the way that the economy has been structured. We also, one thing I failed to mention is we need laws that also require employers not only to be legally responsible for their own direct employees, but expanding employment rights law to apply to subcontracted and independent contracted workers, because that's the thing that they're using to get out of responsibility. And so people, because they're subcontracted and they're independent contractors and, you know, temporary workers, people are not organized. I mean, the whole structure of the economy in labor law is such that it isolates workers and alienates workers. And so they're not. And that's what organizations like ours do, is look for experiment with new models of how we can bring people together, because the infrastructure is gone.
Great. Thank you both so much for sharing your wisdom. And we'll close out with Carrie to talk about police accountability.
Got to unmute. Thanks, Lindsay. And thank you to all the participants who are tuning in to hear about these important issues. This past May, the killing of George Floyd, a Black Minnesota resident, by Minneapolis police officers sparked protests that have spread across the United States and the globe. Mr. Floyd's murder, and recently the failure to charge any police officers in the death of Breonna Taylor, a Kentucky resident who was killed by law enforcement officers while sleeping in her apartment, are both emblematic of the pervasive and racially disparate police violence that plagues US cities and towns. As Ms. Taylor's case most recently illustrates, there is little accountability, even for deadly violence exacted at the hands of the state. And this lack of any real disincentive against violence is now impacting protesters and journalists who are reporting on the protests. US laws at the federal level and in all 50 states fall far short of international standards regarding police use of force or prevention of extrajudicial state-involved killings. When discussing the failures of policing in the United States, there are essentially three main points to consider. The first is the fact that police use of force disproportionately affects racial and ethnic minorities. And the statistics here paint a grim picture. Black people are 3 times more likely than white people to be killed by police. Black men face a 1 in 1,000 chance of being killed by police in their lifetime. 8 of the largest 100 city police departments kill Black men at higher rates than the US murder rate. Black people are about 12 to 13% of the population, but they account for at least 24% of those killed by police. And there are some studies that put that figure as high as 32%. In Minneapolis, here where Mr. Floyd was killed, since 2015, police used force against Black people at a rate at least 7 times that of white people. For young men of color, police use of force is among the leading causes of death. And significantly, Hispanic Americans and Native Americans are also disproportionately killed by police. It should be noted that the US fails to track police killings on a national basis. And so in this absence of definitive official data, it's been journalists who have stepped into the void to do a deep dive and make some systematic efforts to try and track these deaths. The effects of such racially unequal exposure to the risk of state violence cannot be understated, and indeed should be seen as a public health issue. And there are real consequences, not just for public health, but for democracy itself. With less robust social welfare and public health programs, police and prisons have become the catch-all to social problems. And nowhere is this seen more starkly than in the Black population. And one last note here, estimates also suggest that 25 to over 50% of fatal encounters with police involve individuals with mental illness, which is just another indication of how this is a public health issue and we are failing our most vulnerable. The second point to address in examining police shortfalls in the US is the fact that there are simply insufficient legal remedies that exist to address police misconduct. Under international human rights law, the state has the central obligation to respect and protect each person's life, liberty, and security, regardless of the color of their skin. US authorities in all 50 states and at every level of government fail to prevent arbitrary deprivation of life and fail to comply with international standards on the use of lethal and potentially lethal force by a law enforcement officer. Not only that, police officers who kill civilians in the line of duty are rarely held accountable. From 2013 to 2019, 99% of police killings did not result in officers being charged with a crime. From 2005 to 2019, a comprehensive study found that just 98 non-federal law enforcement officers were charged with a crime in connection with a fatal shooting, and only 35 were convicted of any crime. And in cases where the officer was convicted, more often it was for a lesser crime than murder. And it's no small detail to note that the majority of the police victims were not armed with a dangerous weapon. And last point, in Minnesota, in particular, where Mr. Floyd was killed, of the handful of officers prosecuted here, only one resulted in a conviction, and that was of a Black Somali American officer who shot a white woman. Now, there are many reasons behind this lack of legal remedies, and all of which are areas that are ripe for reform. First is the fact that most jurisdictions have overbroad deadly force statutes. For example, in Minnesota, a police officer is justified in using deadly force based on his reasonable belief, which obviously can be very subjective and open to interpretation. Most states also use generally applicable statutes to prosecute police misconduct, such as general statutes prohibiting criminal homicide or assault. What this does is fail to recognize the imbalance of power in these situations and the fact that these officers of the state have a heightened duty to protect those they serve. Violence between civilians is qualitatively different than violence exacted against civilians at the hands of the state. Yet it remains a fact that all 50 states provide harsher penalties when a law enforcement officer is the victim, but not when an armed officer of the police kills a citizen. While it is true that police officers take on an additional and often significant risk in the course of their duties, they also assume an elevated duty of public trust and therefore an enhanced duty of care. Many international human rights standards exist precisely to limit abuses of this power by armed state actors. So laws which perpetuate the imbalances and racial disparities that allow extrajudicial killings to occur are part of the problem. Differential treatment where police officers are victims weakens accountability. And when it also includes policies that enhance punishment for crimes committed against law enforcement officers, it only ensures the continued power imbalance between citizens and police officers. Another reason behind the difficulty in attaining legal recourse is the judicial doctrine of qualified immunity. This is another way that police officers avoid accountability for their actions. Qualified immunity was originally created to afford protection from liability to public officials who acted in good faith and believed that their conduct was authorized by law. But over the years, the courts have expanded qualified immunity to erect often insurmountable barriers to accountability for use of police force. From 2005 to 2008, appeals courts granted qualified immunity in 44% of cases. But from 2016 to 2019, that number increased to 57%. This past summer, the US Supreme Court had an opportunity to re-examine the qualified immunity. There were several cases before them, but they declined to hear any of these cases. So the doctrine remains untouched, and it will continue to exist, as many critics have called it, a catch-22 that says to the victims, in effect, heads, the police win, tails, you lose. The next barrier in the way of police reform are police union contracts. These contracts are notoriously skewed in favor of protecting police officers and shielding them from liability or accountability. Oftentimes, police union contracts make it nearly impossible for people to get justice for mistreatment by the police. Police unions make these contracts with their city, but they are almost always made in secret, and all too often, cities simply negotiate away their ability to hold police officers accountable. And they essentially let police unions write the rules for how their own officers will be investigated and disciplined. And tied in with these police contracts is the general fact that investigations here lack independent oversight. Instead of an outside, independent, and impartial body, most investigations are conducted internally by law enforcement, by the agencies themselves. And the reason I say this ties back into police contracts is because this is the framework that almost all these contracts set up. By design, they shield these officers from independent oversight. And the next factor is the culture itself of these police departments. And the culture of police departments can stand as one of the greatest barriers to police reform and accountability, and is also something that would likely take the longest to change. Policies and rules are one thing, but the culture is as important, if not more. Policies tell the officers what they're required to do, but the culture is what they're actually doing and expected to do, and according to which they receive satisfaction, reward, or acknowledgement for what they do. And when these two things don't align, which more often than not they don't, this is where things go awry. A department can have all the great rules and policies they want, but if they don't have a culture of enforcement and accountability for these policies, none of that matters. An example would be where you have a peer officer who can go to another officer and say, whoa, this is not what we do. You're tainting the badge. We don't do this. You want a culture where it's expected and encouraged for officers to be able to do that. Importantly, though, even where there seems to be a political will to reform police departments, it has faltered. Minneapolis, right here in Minneapolis, is a perfect example, where right after the George Floyd murder, just this summer, a majority of the Minneapolis City Council pledged to defund the city's police department. But as the New York Times reported just this past weekend, these plans have completely fallen apart as of now, basically over a disagreement as to what was really meant by the politically charged words, defund the police. So we're kind of back to where we started there. This past June, after George Floyd's murder, President Trump did sign an executive order purporting to propose police reforms, but it falls far short of what is needed in this moment. The order essentially does three things. First, it conditions federal grants on the meeting of certain standards within police departments, like, for example, prohibiting the use of chokeholds. However, it leaves an exception to that where it says, except in those situations where the use of deadly force is allowed by law, which leaves it open to interpretation. Second, it creates a national registry to track officers who are fired or resign over misconduct allegations, ostensibly so that if an officer is fired from one department, he doesn't try to go work for another department. And then three, federal support of efforts to train police officers in handling encounters with those suffering from mental health issues, homelessness, and addiction, including the development of co-responder programs that would pair local police with social workers, where basically the social workers and the police go out on calls together. And while these provisions sound nice, the order has come under criticism for simply tinkering at the edges of the problem where more dramatic reforms are needed. Most glaringly, it should be noted that the order does not address larger concerns about systemic racism and racial profiling in law enforcement. This could be because the current administration refuses to admit the problem exists. As the US stakeholder report submitted to the Human Rights Council this past August claimed, the US government under Trump, and I quote, expressly rejects the notion that law enforcement in the United States is systemically racist. Obviously, this is something that we take issue with. Groups such as the National Alliance for Mental Health, in conjunction with numerous partner organizations, have responded to this executive order as well. They all signed on to an open letter asserting that the action does not go far enough, and it doesn't go far enough to reduce the role of law enforcement in communities' crisis response, especially mental health crisis response. And the letter also asserts the need to address the disparities in the behavioral health system when meeting the needs of communities of color, something the groups insist is crucial in moving forward. House Democrats do have their own legislative package that goes a little farther. It would strictly, unequivocally ban police chokeholds. It would make it easier for victims of police violence to sue officers and departments, and it creates a national database of police misconduct. However, it has not gone any farther than the House right now, and probably won't during this administration. Then I'll get to the last main point to look at in discussing policing in the US, and this is one that's become more of an issue lately, and that is that in the past few months, law enforcement has overreached even further by using excessive force against both protesters and journalists. As I mentioned in my introduction, the murder of individuals like George Floyd and Breonna Taylor, and the continuing lack of accountability and system change has resulted in widespread protests in the United States. And the vast majority of these protests have been peaceful. Yet credible reports show unnecessary and disproportionate use of force by law enforcement, including the US Department of Homeland Security and the National Guard. And they've used indiscriminate use of less lethal weapons and ammunition such as tear gas, rubber bullets, and flashbang grenades. Oftentimes these methods were used against protesters who were retreating, who were seeking shelter, or in one case in Minneapolis, standing on their own front porch, and I think Carter has a video that I was going to show you. There was an instance in Minneapolis where the Minneapolis cop was just driving through the protesters, here it comes, and randomly just sprayed pepper spray out at the people that were standing on the streets. I think it's coming, but here we go. Here we go. Thanks, Carter. And you probably also saw, I think most people saw the incident probably across the world where President Trump cleared the way of protesters in DC so that he could walk to the church and hold up an upside down Bible. So that's another example. And besides the protesters, there have been several reported incidents of law enforcement physically attacking, intimidating, and arbitrarily arresting journalists that are covering the protests, even when their press credentials were clearly visible. There was an example with CNN with the Omar Jimenez. He was arrested on live TV. You could see his credentials. He was telling them he was with the press, but they arrested him anyway. So besides these exhibitions of uncalled for and disproportionate violence at the hands of law enforcement, there have also been, particularly in Portland, Oregon, reports of arbitrary arrests, detention without charge, and short-term disappearances. And it bears noting here the chilling statement of acting DHS Secretary Chad Wolf that was reported by the New York Times, where he stated that his agency will not allow anarchists, disruptors, and opportunists to exploit the ongoing civil unrest to loot and destroy our communities. While the department respects every American's right to protest peacefully, violence and civil unrest will not be tolerated. We will control the situation and protect the American people and the homeland at any cost. And as this council knows, international human rights standards explicitly forbid defense of public safety at any cost. Further exacerbating these actions and this sentiment, DHS has attempted to justify its tactics in Portland by claiming it was protecting federal property from graffiti. And this is called the broken windows policing strategy, of which its proponents have long cast graffiti in the same terms reserved for gang affiliation and drug crime, and for which they justify the use of absurdly draconian felony charges against Black and Brown communities. What's unfolded in Portland and other communities has rightly horrified many people as an extraordinary crackdown on First Amendment protected activity and a terrifying disregard for Fourth Amendment guarantees against unlawful search and seizure. And finally, just wanted to touch on, given the current COVID-19 pandemic, we would be remiss not to mention how this pandemic is exacerbating the already dire effects of the widespread use of racial profiling and the stark racial disparities in arrests, convictions, and sentencing. Racial and ethnic minorities are disproportionately represented in both criminal and immigration detention facilities, where individuals are particularly vulnerable to COVID-19. And as Lon mentioned, detention facilities are overcrowded and lack many basic protective measures, and it has been reported that those in detention are not getting the attention and the health care they need. And this means that the racial minorities present in these facilities are put at increased risk of contracting this deadly disease, driving the final nail into the coffin of racial justice in the US. And we do have, if you've probably seen our list of recommendations on the one pager, there's several of them, but I would just like to highlight a couple that we think are the most important and the most imminent. First is to establish these independent oversight bodies with jurisdiction over police conduct. We have to take it out of the internal law enforcement themselves and put an independent body that has real authority to conduct these impartial investigations and to give real consequences. We think there should be we should conduct a full review of police procedures nationally and cooperate with state and local authorities to provide training for law enforcement officers to promote compliance with international human rights standards and stuff like de-escalation of use of force, racial sensitivity training, that type of thing across the nation. That's it in a nutshell, if there are questions.
Thank you, Carrie. I know we're at 10:02, so if people need to leave, feel free, but we do have the room for a bit longer, so do feel free to ask questions via that Q&A box. One question we received was if you could comment on what happens when an officer is charged with a wrongful or excessive use of force. Do they get to keep their jobs, pay, etc.?
Oftentimes they do keep their jobs. They're just put on administrative leave or they get moved to a desk job. And even when they're dismissed, they often get reinstated through the union arbitration. And that's where those police union contracts come back and as a safety for them and put them back where they were.
Great, thank you. And I know that does depend on each state's law, but overall that does tend to be the theme. While we give people a few more minutes just to ruminate on any last minute questions, do feel free to email us if you have them after the panel. Do any of the panelists want to provide their kind of top priority recommendation that they'd like the delegates to bring to close us out?
I'll just reiterate the last two that I said, which would be these independent oversights for all of these officers where there can be real consequences and real administration of justice.
I would be happy to also reiterate our recommendation to demand that the U.S. abide by its non-refoulement obligations under international law and provide protection to asylum seekers in the U.S. There is a clear, for the first time in all the years that I have practiced immigration law, a clear goal of the U.S. now to really destroy the asylum program and obligations of the U.S. And it is critical that we ask the U.S. to abide by its international obligations to provide protection to individuals who are seeking protection from persecution on account of political opinion, race, religion, membership in a particular social group, and nationality. The law has not changed in the U.S. It's a policy decision since 2017 to narrow it and ignore it.
Thanks, Juan. And I'm just going to put in the chat box a link to the Advocates website where we've included kind of an update on current a tax on asylum policy if people are interested in looking at those. Veronica, go ahead.
Yeah, I'll just add just expanding labor rights to both to protect workers more against retaliation, to ensure that they are applying to subcontracted workers and independent contractors, and fully funding the departments and ensuring that the funding also is moving through to nonprofit organizations like ours to be in partnership with the federal government.
Thank you. Well, with that, I will say thank you all for joining us this morning or whatever time it is in your respective time zones. Thank you to our panelists for sharing their insights and for the advocates for organizing this event. And again, do reach out if you have any additional questions or follow-up. Take care, everybody.